Further, Mr. Charron?
No.
Rested? Have you rested?
Yes.
Thank you. Closing arguments. Ms. Haruhu?
Thank you. The grievance administrator's burden of proof in this matter is simply preponderance of the evidence. That is our burden. I believe we've established each of these charges of misconduct by a preponderance of the evidence. I like to go through them. The first thing we charge Mr. Charron with is 3.4C, which is knowingly disobeying an obligation under the rules of a tribunal. It is, of course, not disputed here that there was an injunction in place against Mr. Charron's client, Mr. Schnorr. You have that court order, and we've discussed it in detail. Mr. Schnorr was prohibited from transferring those assets without court approval outside the ordinary course of business. And although Mr. Charron has argued that only Mr. Schnorr was bound by that, that is just not true. And this issue was also heard and adjudicated by the trial court. And the trial court found or concluded that under MCR 3310C4, the injunctive order of a court also binds attorneys in an action. And Mr. Charron here, that is really the crux. Mr. Charron was wearing two hats. Mr. Charron wasn't just a secure creditor. He was also the attorney of record for a party in the case that had an injunction. And despite the fact that he wanted to go through with this UCC sale, the reality of the fact is that there was a court order. And that isn't always the case when there's an Article 9 sale. There's no court order. Yes, you can go forward. He has his rights as a secure creditor. But in this case, there was a court order that he knew about. And that goes to the second part of the rule, the knowingly disobeying an obligation part. He knew about this order. He knew that the order was problematic. He knew that it was a hurdle. And that's why we see his emails to Mr. Young saying that I may need to file a motion with Yates to have him approve the transfer. Alternatively, we don't do this, and we argue that this was done in an ordinary course. The point of that email is that Mr. Charron knew. He knew that that order prohibited the transfer that he wanted to do, and he did it anyway. And the fact that he used his security interest to negotiate this Article 9 sale was simply an end run around the court order, and he knew that, and that's why he didn't disclose it in his email to Mr. Steck. When Mr. Steck asked about it, he didn't disclose it in chambers when he was on the phone with Judge Yates. The reason why he didn't just fess up and say, you know what, these assets have in fact been transferred, and I did it. The reason he didn't say that is because he knew it violated the court order. And that goes to his knowingly disobeying an obligation under the rules of a tribunal. And these findings are also in Judge Yates' extensive written opinions. He stated that the respondent knew the sale was prohibited without court approval, and rather than seek court approval, respondent chose to secure his own fee in his own interest by going forward with the sale without knowledge of the court. That's the finding of the court, and it's prima facie in this case. And that was affirmed by the Court of Appeals. I believe we've established a violation of 3.4C by a preponderance of the evidence. We've also charged him with conduct engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. That's 8.4B. And there are two facets to that rule in this case. The first deceitful part of the case is the transfer itself. And that goes to exactly what I was just arguing to the panel, the fact that this was not done above board. It wasn't presented to the court. It wasn't presented to Morris. It wasn't presented to Mr. Steck. It was done in a clandestine fashion. And that was because he wanted to avoid an outcome where the proceeds of a sale would be paid to Mr. Morris, which he knew was likely. if this had been presented to the court. He wanted to make sure those fees were preserved for him. And that's what we heard in his testimony over and over again. He said at the very beginning of this case, this was about us getting paid. And that meant even if it violated a court order, he was under financial stress. There was a great recession. Things were going down. His client wasn't paying rent. He was constantly learning that his client couldn't pay. And so he wanted to make sure that he got paid. That was his concern, not his duties as an officer of the court, not his being bound by the court order. He wanted to make sure he was going to get paid. And so what Mr. Charron did was decide, I'm going to ask for forgiveness and not permission. And he went forward with this sale. That was dishonest. It was deceitful, the way he went forward with it and then covered it up afterwards when he was asked about it. That is a violation of 8.4b. And I want to be very clear about the court's findings on this count, because Mr. Charron has told you that the court completely dismissed him and his client from this case regarding the UFTA allegation. And those charges were dismissed against him on summary disposition. That is true. But when Judge Yates wrote the opinion on UFTA, he specifically found that respondent and Charron and CNH did engage in a fraudulent transfer. And he simply chose not to impose a judgment against them for that conduct. But he didn't absolve them of that conduct. He said that they violated the UFTA. He also said on page 98, it's page 98 of our exhibits, he said in his decision that there were several badges of fraud that fit this case like a glove. And he laid them out. He talked about the fact that MSG was in pending litigation at the time that this transfer occurred, that all the assets were transferred, not just assets sufficient to satisfy the attorney's fee, that the assets were transferred to an insider, that was Guy Highstand, and that all the other creditors except for Mr. Morris were paid. Fifth Third Bank were paid, the other insurance agencies were paid, Mr. Charron was paid. The only creditor that didn't get paid was Mr. Morris. And those are the factors that he considered to be, Judge Yates considered to be badges of fraud. And he discussed the fact that he thought that this action was fraudulent. He just wasn't going to hit them with a judgment. But his findings do indicate that he believed that David Charron had engaged in fraud and CNH had engaged in fraud. He also said that CNH plainly violated the UFTA in seizing the assets. Those are Judge Yates's findings and conclusions. He found that respondent knew about the court order. He was aware he was violating the court order. He said that he thought respondent's December 2008 email left a false impression that nothing had happened to diminish the value of the assets. That's on page 118. That's a quote pulled directly from Judge Yates's decision. His email left a false impression regarding the diminishment of the assets. He found that respondent directly and actively participated in discussing the terms of the injunctive order. And he found, of course, that this was a textbook example of contempt of court by respondent. So there's nothing about Judge Yates's findings that absolve respondent of this conduct. The conduct was deceitful, it was dishonest, it was fraudulent. And finally, Judge Yates found that the asset sale stripped Morris of the value in his secured interest. And that goes to the harm. So I think we've established 8.4b by a preponderance of the evidence, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. The third substantive charge is knowingly false statements to a third person in representing a client, 4.1. And this goes to misrepresentations to Stan Steck. And of course, this stems from the emails to Stan Steck. Respondent is an officer of the court. He owed a duty of candor to his opposing counsel. I've briefed that issue. I'm not going to exhaust the panel with that, but I've given you cases where attorneys have been found to owe a duty of candor to their opposing counsel. Just because he's in litigation and he's representing a client does not negate his duties of candor as an officer of the court and his duties to avoid misrepresentations to opposing counsel. And we've seen several cases where attorneys have been found in violation of 4.1 for lying to opposing counsel. That's what happened here. I think I've established that by a preponderance of the evidence. The final substantive charge here is 3.5D, undignified or discourteous conduct toward the tribunal. This is related to 6.5A, which we also charge failing to treat others in the legal process with courtesy and respect. You didn't hear a lot of testimony about this today. Frankly, I mean, Mr. Charron admits that he filed a brief in the Michigan Court of Appeals where he made a profane statement about Judge Yates. You've heard a lot in this hearing about how Judge Yates was naive. Judge Yates was led around by Stan Steck. Judge Yates didn't know what he was doing. This was his first case. He kind of fell down on the job. I mean, this case is not about Judge Yates. This case is about Mr. Charron and what he's done wrong. And I think what you've heard is in this testimony is that Mr. Charron doesn't take responsibility for it, does not feel accountable for it, but he admits that he made this statement in his brief. The Court of Appeals sanctioned him for it. He paid $1,000 sanction. It is misconduct to make a statement calling the trial court a bitch for the opposing party. Calling the trial court a bitch for the opposing party. That is a violation of 3.5D. It's discourteous to the court, and it's a violation of 6.5A. It fails to treat a court officer with courtesy and respect. And we've seen a previous type of misconduct adjudicated by the Attorney Discipline Board and then the Michigan Supreme Court in the Grievance Administrator versus Feiger case, the 2006 Feiger case. The site is 476 Mich 231. And in that case, Feiger made personally insulting remarks about Court of Appeals justices in a case he was involved in on a radio program where he called the judges jackasses and compared them to Nazis. And his defense to that was that this was a First Amendment issue. And the Supreme Court found that it was not. The Supreme Court found that remarks like that could only bring disrepute on the legal system, and that they violated the Michigan rules of professional conduct. And the court also found that it did not matter that the remarks did not take place in the courtroom directly in front of the court because they were directed to the court. And that's what we have here. This was filed in a brief that was public record that Mr. Charron knew would be public record. And it was a disrespectful remark to the court, and the Court of Appeals properly sanctioned him for it. I think we've established by a preponderance of the evidence that he's violated MRPC 3.5D and 6.5A. I don't think I have anything else. We've established each charged by a preponderance of the evidence. You, of course, have a whole body of findings by the courts that are prima facie evidence of these facts, and clear factual findings and clear conclusions as to the legal issues in this case that can also guide the panel. I know the panel is going to review these issues and give the court orders the weight that you feel is appropriate. But I do just want to, point out that the court did also make conclusions of law regarding these issues too. And I hope that you review those and that you find that they are persuasive. I don't have anything else unless the panel has questions for me.